Howdy, I'm attorney Rick Davis. I'm the founder of Rick Davis and Associates, a law firm in Bryan, Texas. Today I would like to talk to you about discovery in criminal cases. Now, this law firm practices criminal law, family law, and personal injury law. So we also handle some civil cases. Discovery is very common in civil cases. For example, lawyers could propound to the other party requests for production of documents and other things, interrogatories, which are questions that have to be answered under oath, requests for admissions, and other things like that. Up until about 2014, discovery was not very prevalent in criminal cases in Texas. Now, in 1963, the United States Supreme Court decided a case called Brady versus Maryland. In that case, the U.S. Supreme Court decided that a prosecutor has an ethical obligation to produce to the defense, that is to the defense attorney, any information that tends to exculpate the defendant, which means that tends to show that the defendant is not guilty. And the rationale behind this rule is that the power of the government is so overwhelming and so extensive and expansive that just as a matter of fundamental fairness, the prosecutor should tell the defense if there's anything that helps the defense. And furthermore, it's just a matter of good ethics that a prosecutor should not try to put someone in prison or jail who may be factually innocent of a case. Now, prior to 2014, all across Texas, it was done very differently depending on which prosecutor's office a lawyer had to deal with. And this was basically the policy determined by the elected prosecutor, whether that's a county attorney or a district attorney. Some counties had open file policies where they would let the defense lawyer look at the entire state's file. They would just have an envelope saying attorney-client privileged or attorney work product, because the defense lawyers are never going to be entitled to look at the prosecutor's closing argument beforehand or their opening statement or their witness questions that they're going to ask witnesses on the stand. But anything else that constitutes evidence, some prosecutors were already willing to let the defense see everything. Other counties were a lot more restrained in what they would allow the defense to see. For example, I know of a county in times past where if a lawyer wanted to see a DWI video, that is a dash cam video or a body cam video, in a DWI case, they would actually have to go to the prosecutor's office and watch the video in a conference room, as opposed to simply giving the lawyer a copy of the video. That all changed in 2014. In 2014, on January 1st, the Michael Morton Act took effect, and it is based on a very infamous case that arose out of Williamson County, Texas. There was a district attorney in the 80s named Ken Anderson who prosecuted a man for murdering his wife. This man was he was a young man. They had not been married very long. They had a small child, a toddler, a little boy, and he was a produce manager at a grocery store. Well, he and his wife had dinner the night before. He was kind of disappointed how the evening went because it was his birthday. He left a note for his wife, but he went off to work early before she even awoke. Ultimately, tragically, what happened was after he went to work, a man broke into the house and murdered his wife, and he beat her to death. The little boy saw this. This was a huge tragedy. The prosecutors, however, because they saw the note that the man left behind for his wife after he went to work, decided that he was the defendant and he was the one who murdered his own wife. And the prosecution did not reveal to the defense a lot of evidence that was suspect or would tend to show that the defendant didn't do that. Well, Mr. Morton took the case to trial. He didn't believe he had anything to worry about because he knew that he was factually innocent. Tragically, the jury convicted him. It later came out through some efforts by the Innocence Project that actually went back and looked at the evidence of the case and actually asked for and obtained an order for DNA testing, that there was a bloody handkerchief in the backyard of the house that had someone else's DNA on it and someone else's blood on it. And also, the sheriff had concealed from the defense the fact that the little toddler had talked about the man with the red gloves. Well, the little boy wouldn't refer to his own father that way. He was referring to the man who had blood all over his hands after having just killed the boy's mother. Well, the prosecutor concealed all of this from the defense, and it later came out. That prosecutor, by the way, went on to become a district judge in Williamson County. He was ultimately removed from the bench and then later disbarred and ultimately had to spend 180 days in jail on a contempt judgment for having concealed the evidence. He could not be prosecuted for something like tampering with evidence because the statute of limitations had already run. But this caused such a stir in the Texas legislature that they changed a code section in the Texas Code of Criminal Procedure, and Article 39.14 of the Texas Code of Criminal Procedure used to have 2 sections. Now it has 14 sections, and it is very specific about all of the information that the prosecution has to give to the defense. And so now we defense lawyers, we love this because now we get to see everything in every criminal case all across the state of Texas. It's a very powerful tool, and a good defense lawyer will thoroughly evaluate and examine all of the evidence in a defendant's case. For more information about the law, please see us at attorneyrickdavis.com.